the lieutenant governor and the governor that they must move ahead with implementing this law?
I don't think I need to tell them that. The court has spoken, and we move forward. That's the way that our system of government works.
So that means Ohio must move ahead with these.
Well, you'll have to talk. I'm not going to speak for the governor or the lieutenant governor, but I think it's evident that the court has spoken. This matter is resolved in the legal sense. It still is, I think, very much alive in the political arena, and I would expect it to be debated out in the presidential campaign. And if Governor Romney is elected, I would assume he will do what he says, which is to move to repeal the individual mandate. And I assume if there's enough votes to do that, that will happen. But until that time, this is the law of the land.
How does this play out in terms of the constitutional amendment that was passed last year in Ohio? And if there should be a court challenge to prevent Ohio from implementing the federal law, would that put you in a position of having to defend the state, or would you have to defend the constitutional amendment?
I think what the constitutional amendment last year really said was that Ohio, the legislature, the governor, could not implement a similar plan in the state of Ohio. That law is still in effect. But it cannot certainly override what the United States Supreme Court did today.
So if there should be a challenge to the state's implementation of the federal law, your position would be to defend the state?
I don't know how you would defend that.
So just so I understand, follow up on Jim, so what the voters voted on last fall is basically null and void with the decision, the federal decision today?
I wouldn't say it's null and void at all. It still is the law in Ohio. No future legislature could pass something similar, for example, to what Massachusetts did. So it is still in effect. But as far as the specific question I got was whether or not that overrides the Supreme Court decision, and the answer is no.
I'm sorry, you said whether it overrides, you said no, is the answer, it does not override.
Yeah, Ohio cannot override federal government.
So you would
We
not.
fought a war in the 1860s, as I recall.
So you would not.
And we were on the winning side.
So you would not lead a legal challenge trying to uphold the Ohio constitutional amendment.
Well, I'm not trying to parse words, but I think we have to be very careful what we say. The Ohio constitutional amendment is still in effect. It prohibits Ohio from passing a health care plan in the state of Ohio that is prescribed in that constitutional amendment. So it's still very much in effect. It does not mean that it overrides what the federal government has done.
It could override what Ohio might do, but it does not override what...
It tells Ohio that in the state legislature, the governor cannot put in Ohio their own individual, their own state plan to do this. What else?
General, when you heard that it was Justice Roberts who was the deciding vote, what was your reaction?
My reaction was that the president never knows what's going to happen, and there's a long history of that with, Eisenhower talking about Earl Warren and Nixon and Blackburn, and who could go on and on. So they're appointed for life, and one never knows what decisions will be made. But I think that that's kind of a flippant answer, but I think it is very significant. And I can't look into the Chief Justice's mind, but it is very interesting that he made the decision. Not only was he the deciding vote in how it came out in the end, he was also the deciding vote on the Commerce Clause issue. And I think constitutional scholars and I think people who are interested in liberty and freedom and were worried, as I was, that if the court came down in favor of saying that the Commerce Clause allowed this to take place, that there would be no end to what Congress would do. There would be no limit to what Congress can do. Justice Alito basically asked the Solicitor General of the United States that question solicitor of the United States could not answer that. And he could not answer that because there is no answer. And so I think that Roberts was looking at this and said, there would be no limit. And 5 justices of the United States Supreme Court today said there's basically no limit if you accept this argument. So they accepted our argument. And I think that bodes very well for those who care about limiting Congress and limiting the president and limiting the federal government. And so for that, I think we can be very, very grateful. We may have lost this battle, but we certainly won the war today in regard to liberty and freedom and what the federal government can compel us as individuals to do based on the Commerce Clause.
The individual mandate's been around for nearly 20 years now, I think. It emerged as a Republican in response to Hillary Clinton.
I missed the first part of what you said, I'm sorry.
So the individual mandate has been around as a concept for almost 20 years and emerged as a Republican alternative to the single-payer idea.
Doesn't make it good,
Well, I'm just curious. A lot of your Republican colleagues in the Senate, I think, signed on to various bills in the past. I'm wondering, did you ever express concern about the unconstitutionality in those days? Or?
I would have to go back. I don't recall. I don't. This was not a law that was passed, and it was not directly in front of us.
The upholding of the purchase mandate for insurance. Could you just give us a couple or 3 adjectives that, in your mind, describe that ruling?
I'm not sure I understand the question. Give me the question again.
Surprising? I don't know. Just give us a couple adjectives that would describe it. In your mind.
Well, we always thought this case was a closed case. What I don't think we counted on, and we thought it was going to be decided on based on the Commerce Clause. What we did not count on is that 5 of the justices, 5 of the 9, would find what the Obama administration said it wasn't, which was a tax. To my knowledge, I don't think any of the lower courts bought that tax argument either. So the Obama administration originally said it was not a tax. It was passed as not a tax. The appellate courts didn't buy the argument that it was a tax. So for the first time today, we have 5 justices of the Supreme Court, people who really matter, who say it's a tax. And so that was very surprising. That part of it.
I have a question. One more question. I'm sorry, I need to look back there. From the ruling, I heard they said something about the Medicaid subsidy, that they kind of left that in the state's bailiwick about whether they decide whether they can take the Medicaid subsidy for the poor. It's early on.
Sure. The court ruled in our favor, in Ohio's favor and other states, in regard to the Medicaid issue. And what the court said was that the federal government could not blackmail the states by threatening to take away all of their Medicaid money if they did not buy into the new expansion Medicaid program.
Does that mean Ohio will not go ahead with its...
Well, that's not my job to make that decision. That's a question for the governor. I'm just a lawyer for the governors.
What's the price tag going to be, you think, of taking Ohio into this challenge as far as just legal bills of, a year and a half?
As far as our...
Yeah.
Our cost, and I stated this at the time, this is no new news, no breaking news here, we put in $10,000 for suit.
What was that? I'm sorry, what was that?
$10,000. I announced that at the time when we did it. $10,000. All the states did pool money and put money in. We hired a lawyer, we hired Paul Clement to argue the case. So that's the deal. And I would say it's money very, very well spent because with the victory in the Medicaid provision, again, it's up to the Kasich administration what they do with this. And I would not venture to guess or even suggest, but to have the flexibility they in that regard is worth, obviously millions of dollars. So I think that was a $10,000 very, very well spent. Anybody else?
Does this take, the Commerce Clause decision, does that limit other congressional authority, in your opinion?
I think it's defining, it is one of a series of defining Commerce Clause decisions that will be studied in law school and studied by any legal scholars. I mean, it's not the only Commerce Clause decision, obviously, but it is the most recent. And it is a very significant one, it is a landmark one. And it would have been more significant. It would have changed the way we look at the Commerce Clause if the decision had been made that it was acceptable, that this law was upheld based on this Commerce Clause. The fact that it was not is very significant. So, to me, it's the concern that I have expressed, and I've always expressed this to people. I said, look, we need to worry about Obamacare. We think that is bad. We think it's unconstitutional. But the bigger question is this, and the much more important question is, if the federal government if the Supreme Court upholds Obamacare based on the Commerce Clause, then, the floodgates are open. There is no limit on what Congress can do. So that to me is a very, very significant thing. I have not read the whole opinion, and I think the question that we all should ask is, what is the limitation of the tax clause? And we have to look at that, look at the decision, and I think an argument could be made that, I have to wait till I read the whole decision.
Just to follow up on that, is there a possibility here in the future that any time there was a case that could have been brought based on the Commerce Clause, it'll just be brought as a tax now?
Well, I think one could get into that. I got to read the decision, so I don't know the answer to the question. I just don't know the answer to the question. One could argue that it's more difficult to get something passed as a tax than it is to pass under the guise of the Commerce Clause. So from a practical, political point of view, it may be fundamentally different. It's very interesting. We could speculate. If this had been sold as a tax, would it have been passed? I don't know. But you have the interesting situation where it was sold as not a tax. And it may not have ever been able to be sold as a tax, but it passed because it wasn't a tax, and the Supreme Court says it is a tax. So it's quite interesting.
General, is this decision, do you think it's good for the 1.5 or 1.2 million Ohioans who are currently uninsured?
I've always said that there's a lot of this bill that is good, and there's a lot of things that should have been passed, frankly, in a bipartisan way, which is what my hope had been, that we would have been able to do what we did with Medicare and civil rights and Social Security, and that was passed in a bipartisan way. If this had been declared unconstitutional, I would have hoped that Congress would have gone back in a bipartisan way and dealt with all the things that people like about this. What they don't like is an individual mandate. They're adamant about it. But they do like a lot of it. What I hope, frankly, what will happen is that I hope we elect Governor Romney and Congress repeals it, but then goes right back to work and puts together a bipartisan bill that solves the problems that need to be solved without the individual mandate. I think we're back in the political arena, and that's okay. That's where we go.
Are you confident that President Romney would work earnestly to repeal a law very similar to one that you have passed?
That's what he said. I think